Good evening and welcome to PBS Fort Wayne. Our show tonight is Life Ahead. If you've watched us regularly, you know that we have different topics every Wednesday night at 7:30. And you can also see those shows again on YouTube and several times through the weekend on PBS. But tonight, I think you're really going to enjoy the show. We're going to be talking legalese tonight. Is that a word, Bryan?
I hear it a lot.
This is Bryan Nugen, and if you watch us regularly, you know Bryan. He's an attorney, and he's with us about once a month here on Life Ahead for several years now. What did we figure out? 3 years, 4 years?
It's actually, you said that to me on one of the shows, and it's been at least 4 or 5 years.
Really?
Yeah, I went back, and it has been some time.
Wow.
Yeah.
Oh.
Yeah.
See how time flies?
It does, unfortunately. Moves along, we can't stop it.
That's true. But Bryan will have different legal topics each time that he comes. And tonight, though, we're doing something kind of unusual, and I love this idea. We use, and maybe you use as well, a lot of legal terms, or you hear them, and you're not quite sure what it means. Well, that's what we're going to talk about tonight, some of the basic terms.
Okay.
I like that you call them, and I never heard that before you, instruments.
Right.
Does that mean like documents? What does it mean?
So I think generally we hear the term document, but as an attorney, I like to look at them as a legal instrument. It's something that's in writing. It's something that we're writing specifically for that individual. Document to me sounds like it's more of a fill in the blank, and that's definitely not what's happening when you're working with an estate planning or elder law attorney. They're instruments that are unique to you, and they were crafted for you and for your particular
like your
purposes.
Will.
Could be a will. Sure.
Maybe a trust or
Could be a will,
anything
could be a trust,
you're doing legally.
powers of attorney, any of those types of things.
Okay,
Yeah.
all right, we're going to define a lot of those terms tonight, and you can be in on this show too, because we're going to be asking you to give us a call with your legal questions, 969-2720. You can see that on the bottom of the screen, and that'll appear fairly regularly here in the next half hour. Don't be shy. We do have a phone operator back in the control room that'll take your question. We'd love if you talk to us on the air,
Please.
but if you're not comfortable with that, you can give her your question, and I'll give it to Bryan. Okay, Bryan, let's start out here with some of these definitions. Let's start with wills. That's the simplest thing.
So a will is when we're thinking about, at the time of our passing, who it is that we're going to appoint to handle our affairs. In Indiana, we call them a personal representative. So who is it that's going to be acting on our behalf to make sure that our wishes are implemented? And that's a personal representative. That will is an instrument that's written. So I've used the word instrument. It's an instrument that's been written that indicates that someone's debt should be satisfied, what assets they have, assets meaning anything that has a value, what assets need to go to a particular person or to a particular charity or religious organization, what percentage of one's estate should go to any of those entities, etc. So it's an instrument that spells out when I pass, where everything should be distributed, how my debt should be handled, who it is that's going to be in charge of that. And by using a will, we go through something called probate.
And we're going to talk about probate a little bit more, but tell me, living, we said will.
Right.
Living will, that is different.
Living will is very different. So a living will, you can think of it as, do I have the desire, do I have the will to live if in essence, the effort to sustain my life is futile? So if I'm actively passing, the doctors have done everything they can do, there's nothing more that can be done for an individual. In that instance, do you have the will to live? Or are you saying that it's okay to let me go? You don't need to keep me alive in a vegetative state. I'm not asking for any of that. Please allow me to go. What I will say, Sandy, about living wills is that despite their being in writing, I always encourage folks to speak with their loved ones, speak with those around them to make sure that they know what it is that you want in that instance. You think because it's in writing, it's black and white, it makes it a lot easier. Sometimes it does. I think really what it does, that living will does, is that it removes guilt from the loved ones that are having to make those decisions on your behalf. So if you've taken the opportunity to speak with them in advance, you've let them know what it is that you do or that you don't want to have happen in that instance, it really removes a lot of guilt for them. And that living will is backing it up for sure, but that conversation cannot be
It's
avoided,
great.
and I encourage it.
Great idea. A
you.
lot of people aren't comfortable with that, but I wish they would be, because
Yeah.
it's great for the people still here.
Well, if you're uncomfortable now, when
Yeah.
you're healthy and things are going well, the conversation doesn't get any easier
Yeah.
in an emergency situation
Yeah.
or when you're not doing very well. So bring those things up when it's a conversation like this, when you're talking with
Yeah.
them, you're in a comfortable setting, when you're not surrounded by doctors, you're not surrounded by other folks and you're distracted, or there's an emergency situation going on. Talk about it when you're at the campfire in the fall, or you have a getaway at the lake, or you're have your family member over for a Sunday night dinner. You're playing cards.
Yeah.
Just make it a normal part of discussion. It isn't something to be feared. Death is inevitable, unfortunately. But if you've had that conversation with folks, or if you've been put in the situation of needing to make that decision for someone, you most definitely recognize how much easier it is to make that decision if you've had that discussion with the person that's been appointed you as their
Yeah.
representative in that instance.
And it doesn't have to, if you're not comfortable with it, this is my theory.
Sure.
You don't have to have one conversation for 2 hours and go through everything.
No.
You could just throw little bits out
Yeah.
here and there,
Yep.
While you're doing dishes after Thanksgiving, you could say,
Exactly.
oh, by the way, I want to be cremated, or something casual like that.
I agree with you. It is not something. It's a conversation that's healthy.
Yeah.
And you're having the conversation. You gave the reference of a Thanksgiving dinner. I typically will say that too at holidays, when it's not an uncomfortable time. People are uplifted and have
Yeah.
In this instance I would want that. In this instance I would want this. And
Right.
so you're dropping those little pearls of wisdom. So when the event happens,
Yeah.
you've educated those around you, and it's easier for them to make that decision.
Right, and less guilt, because they know
Yep.
you've said that with your words. This is
Yep.
what I want,
Yep.
And when we were talking about living wills, isn't there something in there about, let's see, that you can say, I don't want to
So in Indiana-
come back to life or whatever.
A DNR, do not
I can-
resuscitate. So,
But you can do nutrition and water? Is that it?
A traditional living will in Indiana gives you three choices. The first choice is keep me alive at all costs. I want to be kept alive in a vegetative state, so give me artificial hydration and nutrition. The second option is generally, I don't want to receive artificial hydration and
Yeah.
nutrition, just let me go. The third option is, I don't want to make a choice. I want someone that I've appointed to make the decision for me.
That's your healthcare representative?
That's your healthcare representative. Yep, you got it. We're now seeing within our healthcare representative designation forms that living will language is embedded in that, as opposed to being a separate document.
Okay.
Yeah.
And where do you keep that? I mean, your living will, does that have
your
to
living
be
will,
part of your will and testament?
Well, it's not part of last will and testament. It's a completely separate document. Where should you maintain it? First, if you do have loved ones that are helping you make those decisions, I would encourage you to give them a copy. I would also encourage you to have it with your medical file, with your primary care physician, to make sure they have it on record there.
Yeah.
And then wherever you keep important papers. Sometimes people will, I don't necessarily think that the document should be kept at the bank in a safety deposit box when you can't get to it.
You got to find the key first.
Keep your key. You got to find the key. You got to get to the bank, and they may have set hours. Keep it wherever you keep your important papers at home, and then let your family members, the decision makers, know where they're located. I also like the idea. There are digital ways that you can store those documents online. So, for example, if you're traveling and you referenced a healthcare rep designation, or you need a living will, and it's back in Indiana, gosh darn it, wait a minute. We're using this service where we can store those documents online, so you can have access to them 24 hours a day.
Wherever you are.
If you've submitted them to your primary care physician, that primary care physician is part of a larger network. Those documents then are typically shared network-wide. But yes, make them available to yourself and to those that are decision makers and medical professionals in your life as well.
Well, in addition to having the talk with them about your will and testament, you might also make sure that you have a conversation with your family. Again, you could throw this in here and there, where your documents are.
All those things.
And I don't know, I mean, like in the desk in the second bedroom upstairs in the third drawer, I don't know.
There you go.
Or in the green folder, whatever. But
Whatever they may be.
Well, what else should you include, Brian, that you should leave for your family in addition to the will or a living will?
So essential estate planning. So we want to make sure everybody needs a will. The will could be, as I say, one that's taking us through probate. It could be a will that's indicating that if I have a trust and the assets I have, I pour over into that trust. We want to make sure we have a healthcare representative designation prepared, meaning if you're unable to make healthcare decisions for yourself, who is it that's going to make those healthcare decisions for you? So sometimes people have the concern that if I sign that healthcare representative designation, I'm no longer able to make decisions for myself. It's like a guardianship. It isn't a guardianship. You're in complete charge. It only comes into play if there's a point in time where you're incompetent or incapable of answering questions regarding your medical care. So last will and testament, healthcare representative designation, either with living will language or a separate living will. I like to see separate HIPAA waivers. HIPAA stands for Health Insurance Portability and Accountability Act. Those healthcare representative designation papers typically have that language in it, but my experience has been that hospitals and doctors are used to seeing separate HIPAA waiver forms. So if we have that separate form, you're not having to point out in the document where this language regarding HIPAA is. You have a separate document, and the hospitals and doctors' offices are used to seeing that. So those are some of the very basics that everybody should have in place. I would also encourage them to have something called a durable power of attorney. A durable power of attorney is a document that permits someone to make financial decisions on your behalf. There was a time in Indiana where we could combine financial and healthcare decisions in one document. We can't do that anymore. They have to be separate documents.
But you could have the same person if you wanted.
You can use the same person. Of course you
Okay.
may. Yep. So durable power of attorney, it's allowing someone to do things like signing checks or speaking to an attorney, speaking to the bank, speaking to your financial advisor.
Yeah.
Anything you could do in writing, you're permitting someone else to do on your behalf. Very important to have that in place. With that healthcare rep designation and the durable power of attorney, hopefully we're avoiding the need of a guardianship. Nothing wrong with guardianships. They're very appropriate. I mean, they're done every day. But if we can avoid having to go to court and getting the court involved, just by signing a few documents, you can avoid all of that for your loved
Because
ones.
that takes a probate judge to agree to a guardian, correct?
It does. You need to have a statement from a healthcare provider saying that you are unable to provide care for yourself and you need guidance from somebody else.
We need your guidance for Macy
Sure.
here. She's called in with a question. Macy says, what if you change your final wishes on paper, but you do not update your legal forms? Okay? Or your healthcare representative, do they have to honor your new request?
No, they don't
No.
have to honor your new request. Now, when you say, Macy, you've indicated that you're making your changes on paper. If you're making your changes on paper and you're complying with the requirements of a last will and testament, if you're complying with the requirements of healthcare rep designation, the requirements of a durable power of attorney, yes, then they could be enforceable. But if you're just using a piece of paper and saying, I want this or I want that, those are for majority of the time not used. There are very rare instances when someone's passing and they say out loud, this is what I want things to be done, and it's reduced to writing immediately. There are some exceptions, but generally, no.
Not legal, then.
Don't rely on, I wrote that in a letter to my best friend, or I said I want this to happen or that to happen. I would not count on those being enforceable or usable whatsoever.
So you
No.
can't write a new letter with different wishes or change where you
No,
want
ma'am.
things to go, or
No.
or your healthcare representative,
Or
staple it onto your will and testament.
Or on your will itself. Sometimes I've seen people write on a will. Like they'll scratch
Oh.
a section out, write something in.
Can't do that.
Can't do that. No. So don't assume that because I had a will and I've changed it at some point that I've written over it and I've initialed it, that's enforceable. It's not. I would caution too, people can find these forms in any number of places,
Yeah.
right? You can go online and you can find documents. There's software that's sold. It's so important that these are effective and properly written. I do recognize that it costs money to hire an attorney. I recognize that, but they're so important that they work appropriately for you in that time of need. I would encourage you to make sure that you're getting good counsel. And there are programs where attorneys volunteer their time to do those documents for folks without cost.
Yeah.
So take advantage of Write a Will Days. That happens
Right.
in all over Indiana and surrounding states. So I would encourage folks to take those things very seriously and make sure that you do have them properly signed. Macy, we're not just writing on a piece of paper and assuming that will take place, or saying, a parent saying to children, this is what I want to happen, I want this to happen, I want that to happen. That's not enforceable. So we want to make sure it's in writing and done properly.
Now I forgot my question. You were answering Macy's there. Oh, I know, we're talking about what you can't do. You can't scratch out and write something above on your will. But do I understand, say assets you have, not big ones, not the home or car or whatever, but I don't know, his coffee table or the
Grandma's
stereo
table.
set. Do they still make stereo sets? I don't know. Whatever. You could make a list and say who those things would go to and attach it.
If you can attach that to your will or trust, so long as the will or trust references the fact that you have the right to prepare a memorandum regarding personal property. So yes, you can do a personal property memorandum that's attached to a will or a trust, and that personal property memorandum can say, Grandma's cocktail table goes to Becky, and Grandpa's chest of drawers goes to Steve. You can do that. The nice thing about doing that as a separate memorandum is that if you do want to change your mind at some point regarding where that personal property goes, that is the time that you don't have to do a new will, you don't have to do a new trust. You can write out that memorandum and indicate, I don't want that chest of drawers to go to that person or that cocktail table to go to somebody else. I've changed my mind and I want it to go to a particular entity, particular person. So by referencing it in the will, inside the trust, that you can do personal property memorandums. We can do that without rewriting the entire will, without rewriting the entire trust.
Some of those things might change.
That's correct. Yep. Or I've taken a trip and I bought something that I didn't have at that time, and now I want to be able to give that item of personal property away. So those things may not necessarily have a high cash value, but they have a high value
and a lot
of
of
sentiment.
times it's an emotional.
Without a doubt.
Exactly. And that might save the siblings or grandchildren from arguing, but Grandma told me I could have it.
You got it.
We have another phone call. This is from Sam. And Sam, thank you so much for watching us here on Life Ahead. Sam says, my dad passed away 20 years ago and left me everything, but we never took the will to probate. Since then, my sibling has taken over his property. Whoa. Is it too late to go to probate or to do anything?
So it is too late to go to probate. You have 3 years. Yeah, you have 3 years to go to probate. So if the will, but what I don't understand in the question, Sam, is that when you say take over the property, so there's real property and there's personal property. If it's personal property, that's the table, the chair, those things that are mobile,
or
that don't have a
into
title,
the house.
Versus real property, which is real estate. So I don't know how the brother, I think it was a sibling could have taken over real property without somehow that having been deeded to them. So if that real property, that house, that farm, if the title hasn't been changed at the recorder's office, it's still in the parents, your dad's who had passed away, in his name, you may not be able to probate the will. However, you may still be able to have intestate succession, which means without the will, how does the law indicate the property passes? So intestate succession, if there's more than one sibling living, wouldn't give it all to one sibling, in this instance Sam's sibling that took the property. So if it's personal property, that's going to be an uphill battle to get your piece of that. But if it's real property, it would still be titled in your father's name, and
like the house, the car,
house,
that kind of thing.
The car is not real property. And cars would be handled at the BMV now in Indiana. We can go to the BMV with the death certificate, and we swear how that vehicle was supposed to go. Real property. So this would be a house, a farm, something like that.
But let's say, and I'm just guessing Sam's situation, but maybe he means his brother's living in his dad's
that's
house.
my point. If he's there and he's taken over it, he doesn't own it. He may be there. Now, in order, I'll just throw this in, Sam. in order for your brother to say adverse possession, he would have to be paying the real property taxes there. There are several different standards that he has to meet in order to claim adverse possession, and even with that, he has to go to court and indicate that it should be his.
So he has 3 years to go back to probate.
To file a will with the court
file a will
to open an estate.
Okay,
Yeah.
so in Sam's situation, he better just get some legal counsel and look at
Yeah,
it separately.
if it's real property, I would, without a doubt, get legal
Might
counsel.
be worth it.
Yeah.
Okay, thank you, Sam, so
Thank you.
much.
Appreciate it.
Okay, we still have a few more minutes if any of you would like to give us a call here. Meanwhile, you mentioned HIPAA waiver. Explain again what that is and why we need to know about that.
So when you go to the hospital or you go to the doctor's
sign a
office,
zillion
every time you
forms.
sign, what they're having you sign is for that instance, they're saying it's okay for us to tell your insurance company that you were here, and we're going to tell the insurance company why you were here. So they can't, at the doctor's office, they cannot disclose what treatment they were providing to you unless you say to them, it's okay.
Yeah.
So the HIPAA waiver is an instrument that is more general in nature. It's not limited to just a one-time doctor's office visit or a hospital visit. And we want your healthcare representative to be able to see your medical records if the healthcare representative is being asked to make decisions on your behalf. So to make sure that the groundwork is laid and everything can move forward smoothly, I encourage folks to have a HIPAA waiver in place.
Okay, that makes sense.
Yep.
Okay, we're going to kind of make a group of things here in this question.
Okay.
Trust.
Yes,
Okay,
ma'am.
we have testamentary.
Yes,
Testamentary trust, revocable trust, irrevocable trust, and I don't know, are there others? Well,
So
guarantor.
let's start with trust generally.
Okay.
So trust is not something to be afraid of. Sometimes people say, oh, I don't have enough money, or so trust is a very, very broad category. It's a giant umbrella category. And a trust, in essence, is a contract. And there are 3 players in every trust. We have someone called settlor grantor. I like to say trust maker, because it makes sense. Oh, it's the person that makes the trust, the settlor, the grantor, the trust maker. Then the second position that we have is someone called a trustee. The trustee is the manager of whatever's in the name of the trust. And the third position is beneficiary. That's the person that can benefit from the assets in the trust. So those different types of trusts that you were referencing, Sandy, it's true. We have a broad category of trust. If we slice it down the middle, 1/2 of those trusts are revocable, the other half are irrevocable, more permanent nature. There are ways that those can be changed, but generally we should go into those thinking, I can't change an irrevocable trust. A revocable trust can be changed. And we use different types of trusts for different reasons. So a testamentary trust is a trust created inside the will. So it isn't established until the person passes. Last will and testament.
Inside the will.
Testamentary trust.
Okay.
Yeah. We have living trusts. Those trusts are typically used to avoid the probate process. So as the name suggests, you create those while you're living, and you're wanting to avoid the probate process and distribute your assets after your passing without needing to go to court. We could have special needs or supplemental needs trusts. So if someone's a special needs person, they can receive the funds in that trust, and it doesn't negatively impact their ability to get SSI or their ability to be able to get Medicaid benefits, et cetera. Could be VA benefits as well. So we use those in instances, planning in advance in case the person, at the time the person receives the money, they are special needs, supplemental needs at that time, or if we know they're special needs, supplemental needs at this time currently, we may form a special needs, supplemental needs trust for them. But any number of different trusts there could be for a different reason. So
that's why you need to get some counsel, because you need to make sure your trust matches your situation.
So you make a great point. I'd like to say, when you're speaking with counsel, don't presume what it is that you do or don't need. Really explain to them what it is that you're looking for, the help that you're needing
trying
help
to do,
and rely on them to allow suggestions. Elder law attorneys, estate planning attorneys want to help. They really do want to help you. It isn't something to be afraid of. Go in, ask your question, explain the situation, and allow them to make suggestions to you. Ultimately, you're the decision maker. You decide what you do or don't want to have in place. But if you have that open discussion with a professional, they're going to guide you based upon their experience and their education.
Well, just in talking tonight here about instruments, if you will.
Yep.
Maybe I have learned about a lot of things I just didn't know before, or a lot of terminology I just didn't know was out there and was even possible.
Sure.
Okay, Bryan,
Yes,
our
ma'am.
time has gone way too fast. Thank you, those of you that called in with questions. And Bryan, again, will be back to give us more legal advice in another month or so. Meanwhile, you can keep watching us here on Wednesday nights at 7:30. And this show, by the way, will be available on YouTube. And it'll be airing on other PBS channels throughout the weekend. So lots of opportunity to see you, Bryan.
Thank you. Good to be here. Appreciate it.
Good night, everyone.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, focusing on estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.